You're at the podium. You want to say something?
I simply want to point out I did, over the break, locate and provide 2 additional cases, one of which is, I think, more instructive than the other. The more instructive one is Harrington, Herrington versus States, a 1989 Florida Supreme Court decision. Essentially, quoting one of the rules of criminal procedure and indicating that, according to the Florida Supreme Court, requested instruction on third-degree murder is if there's evidence that the killing was done during the commission of one of the underlying felonies for third-degree murder. Anytime the charging document alleges an offense which can be divided in degrees, such as homicide. In the case of degree crimes, requested instructions on all lesser degrees that are supported by the evidence must be given regardless of the allegations of the charging document. It goes on to specifically discuss manslaughter and third-degree murder in that context. So in addition to the cases I cited this morning, I would be submitting that one as well. The other one is Carwile, C-A-R-W-I-L-E, and that is as it relates to allegations for intent. That is an aggravated child abuse case, so it is simply a case about when it is, and it's a JOA case, so as I said, I'm not sure it's directly opposite, but I think it does point out that the court's question before we left was as to the intent, and the intent is the same for the same act, that is the shooting. That is an intentional act. It's not a separate intent that's required. So I just want to make sure I was clear. I think the other cases also make that point, but Carwile I thought might be instructive along those lines, and if it isn't, it isn't. But Harrington was the principal one, and I just want to make sure that the court was aware that I brought those up.
Okay, thank you. Defense?
Well, likewise, as the court, I just got these cases as we came in here a couple of minutes ago. I certainly haven't had a chance to read them. Would you any
I don't need you to do that. I went back and I looked at all this, and I don't think that the evidence supports a charge to the jury for third-degree felony murder on a child abuse charge. So I'm not going to give that instruction. So I have received your final draft, so it's not so final yet. The change that would need to be made is on the lessers to take out the third-degree felony murder. And then we can just excise out the charges, and and you'll finalize the verdict form.
Yes, Your Honor, we will.
I understand your argument, but I
was only going to ask which part of shooting a child hadn't been established.
Well, I just don't think that the intentional part of that is there for the child abuse charge, and it's not alleged in the information that way. And I just don't think that the evidence supports that. And if I'm not sure about that, I'm not going to charge the jury on it. And I think that to exercise caution, I'm going to deny that being set before the jury.
Understanding that since it's subjected to any error that's been established as reversible will be deemed waived, I hope that we at least protect the record in that regard.
Okay, thank you. So with that being done, are there any objections to the proposed final draft of the jury instructions? That would be changing the lesser included crimes to just allege manslaughter, taking out the charge on felony murder, the justifiable homicide after that, the possession of firearm and discharge causing death after that instruction. Then there was a blank page. Then the next charge would be the manslaughter, justifiable use of deadly force, plea of not guilty, date of crime, venue, weighing the evidence, expert witnesses, George Zimmerman not testifying, George Zimmerman's statements, rules for deliberation, notes, cautionary instruction, verdict, submitting the case to the jury. Any objections other than what the state has already argued? Any other objections from the state?
Other than what was said, no, Your Honor.
Somebody wants to? Yeah.
The only question, Your Honor, is as to the justifiable use of deadly force instruction.
That's
once-
after the second murder.
After the second-degree murder. Or, I think it's actually after the manslaughter.
It's after the manslaughter.
The first paragraph, I believe, is what the defense requested, other than, obviously, we'll remove the reference to the lesser-included offense of third-degree murder, but my understanding, I want to make sure I got Mr. West's requested language exactly as he wanted it. I think I did, but I'm not certain.
Are we looking at the first paragraph in the instruction for justifiable use of deadly force?
Correct. The state inserted the language with which George Zimmerman is charged. The way that I drafted it was it's a defense to the crime of second-degree murder and the lesser-included offense of manslaughter if the death of Trayvon Martin resulted from the justifiable use of deadly force. Okay, I understand. So what if you put it is a defense to the crime of second-degree murder and the lesser-included offense of manslaughter with which George Zimmerman, well, let's put second-degree, leave it as it is, and then after manslaughter, which is a lesser-included offense.
Just, if we could, just strike.
Because he's not charged with manslaughter.
Right. So if we simply struck the language with which George Zimmerman is charged, we've solved the problem. There doesn't seem to be any question that Mr. Zimmerman's charge was second-degree murder in this case.
That's fine? Okay.
That appears otherwise to be,
Taking out the third-degree felony murder. The rest of it
Right.
seems to be correct?
yes, I think so.
Okay. Are there any other instructions being requested by the defense?
Pardon me?
Are there any other instructions being requested by the defense?
I don't know. There's a couple of occasions where words are plural that should be singular now that we've addressed the third-degree murder issue. So that I'm sure the state can
Okay, the
catch
substance,
that.
we can change that. I'm looking for really substantive
Right.
changes. But thank you for pointing that out.
So we're now addressing any other changes?
Nothing else, Judge, thank you.
Okay, thank you. The other thing we'll need to see is the revised verdict form when you have that available.
Yes, ma'am.
Okay, I'm sure Mr. De La Ronda will need to review that.
Yes, and I think, speaking for him, I'd like at least about another 30 minutes just to revise in light of the
decision.
Okay, so if we were to be back here, let's say 1:30, 1:40, he should be ready to go.
Believe so, Your Honor.
Can you have the proposed verdict forms to the defense prior to that? So then I could come in about 1:35 and make sure they're all in order before we start with closings?
I think so, Your Honor.
All right. With that, anything further from the defense at this time? Let me ask you, while you're standing, Mr. Zimmerman, you've had an opportunity to review the jury instructions with counsel?
Yes, Your Honor.
And are these instructions agreeable with you, sir?
Yes, Your Honor.
Okay, thank you very much. Court will be in recess.